So let's start this video by simply describing what exactly is a constitutional court, because they currently don't exist, apparently, anyway. They might exist in some local areas that we never hear about, and we won't hear about as long as there's a information structure that can control everything the way it does. So basically, the concept is pretty simple. We all know it, it just isn't practiced today. And it's a really simple example would be, say, a group of neighbors in a locale get together and begin to discuss how they need to form together to deal with the so-called alleged government in their area, which clearly is acting on the best interests of foreign entities and not their own, not the people that they pretend to serve. Where what they mean by servers, of course, is dominance and tyranny. Just like they did in 1775, when groups of people, merchants, salesmen, tradesmen, various different types of people, they all got together and they said, clearly, we have no interest and we are being screwed and we need to do something about it, right? At that moment, you have the foundation for a constitutional court. The thing that you need to do, which is what they did, is to put it in deed. That means you take an action. To do something in deed, or when somebody says indeed as a prefix, or not a prefix, I don't remember what the word is, but anyway, when in a phrase, a lot of people use the word indeed, and it's usually used to mean that's true or some other phrase like that, but it really means in action, or a deed is an action. Most of us only think of a deed as like a deed to a house, but the deed to a house, in fact, is a part of that concept of putting something into action. In order to demonstrate that you're putting it into action, it usually involves reduction to writing, which is essentially the idea of a contract or contract law. So you reduce something to writing, you affix a signature to it, a seal in many occasions, but not necessary all the time. Essentially, what you do is you take a series of steps to show the intent and to form an action. And once that action is formed, you have, if it's done for the purpose of setting up a court in order to try the crimes of the individuals in the locality that are doing criminal activity in our example, then yes, you would form that paper document, which would form the deed, which would form a constitution of that court. It would constitute the court's existence. And then you can execute writs lawfully according to the Constitution. Of course, that document of the deed would require an oath or a pledge, as with the Declaration of Independence. Now, that's the paperwork part. That's the lawful part. But the most important out of all of this is the enforcement mechanism. And extremely important is that those individuals that would pen their name to such a document would immediately be in great danger. Because currently what we have is a usurpation of the law by a banking court system. And all of those individuals involved in those schemes and those conspiracies, they would want to remove by any means necessary any individual who puts into force, indeed, a constitutional court, because they are the individuals who will then hold them to trial and determine punishment lawfully, according to the legitimate law. The only way that they would be able to stop that is by eliminating the individuals who would pen their name to such a document. And as we all know, the people who signed the Declaration of Independence were instantly in great danger, because what they were doing, according to the opposition, was to them treason. So it depends on which side you're on. You're either on the side of the banking court system or you're on the side of the constitutional court system, but you can't be on both sides. And if you do choose the constitutional court system, you would have to understand that the opposition will use any means necessary to eliminate you. So you'd have to, watch what you eat for poison. You would have to have physical protection around you to avoid assassination. You would essentially have to be the type of individual that is insulated, that doesn't take medications where you can be poisoned through those. An individual who is essentially self-sufficient and capable of insulating oneself against threat of death. And that's a true threat. That's not a fake threat where somebody delivers a letter or harasses you or anything like that. No, they would, in fact, they would have to eliminate you, because the next step, once a constitutional court is formed, is their trial. And once they are tried, which is done in person, and they are not allowed representatives, they have to represent themselves, then they would have, naturally, considering the mountain of evidence against most of these people, they'll be found guilty, and they will be punished accordingly. In our example with the Declaration of Independence, we find their deed being the document written up and then signed by each member. I believe there's something like 52 or 53. In the last part of the document, they pledge, which is your oath or affirmation, their lives and their fortunes to essentially win or lose. If they lose their life and their fortune. If they win, well, they still pledge their life and fortune to their cause. And in it, they pledge it to each other in the Declaration of Independence. This is a document that presents an example of exactly what kind of a deed has to be done to establish and form a constitutional court. There is no requirement for those people to be licensed. There's only the requirement that is listed out in the document. None of these people that signed this Declaration of Independence had law licenses. None of them were, according to the Crown rules that were in place at the time, none of them were legitimate. They simply did it, they put it in force, it was done indeed, and therefore it stood. And that is what a constitutional court is. We get some clarification on this from one of the only sources we're allowed, which is the opposition's perspective, and that is in the Law of Contracts by John William Smith, Esquire, late of the Inner Temple Barrister at Law, the author of leading cases, a treatise, however you want to say that, on mercantile law, etc. Seventh American from the 8th London edition by Vincent T. Thompson, Esquire, M.A., of Lincoln's Inn and of the North Eastern Circuit Barrister at Law, Assistant Recorder of Leeds, with notes and references to both English and American decisions by William Henry Raleigh, or Rall, at George Sharswood, LLD, and with additional notes and references to recent American cases by John Douglas Brown, Jr., Philadelphia, T&J.W. Johnson & Company, 535 Chestnut Street, 1885. Here it states, "For when a man passes a thing by deed, first there is the determination of the mind to do it, and upon that he causes it to be written, which is one part of deliberation, and afterward he puts a seal to it, which is another part of deliberation, and lastly he delivers the writing as his deed, which is the consummation of his resolution, and by the delivery of the deed from him that makes it to whom it is made, he gives his assent to part with the thing contained in the deed to whom he delivers the deed, and this delivery is as a ceremony in law, signifying fully his goodwill that the thing in the deed shall pass from him to the other." Now, like I said, this is from the context of a banking court. This is what they mean by a deed, because they can only act on matters of monetary value. That's very important. A banking court can only act on matters of monetary value. A legitimate court can try things not of monetary value. So here they're talking about a deed in terms of a contract where it comes to something being delivered, a good, something that has value to it monetarily. But as we saw with the Declaration of Independence, that is a deed which, yes, they put up collateral, their fortunes and lives, but it's not required to put something into deed. According to Wikipedia, suo jure is a Latin phrase used in English to mean in his own right or in her own right. We should clarify that jure, where our word jury comes from the French jurer, to swear. Also in Spanish, it's jurar, spelled with the addition of an A instead of an E. But either way, that word means his or her oath. So when they say in his own right or in her own right, they're intentionally mistranslating it because that means his or her oath. The swearing is what gives that authority. In most nobility-related contexts, it means in her own right, since in those situations the phrase is normally used of women. In practice, especially in England, a man rarely derives any style or title from his wife. An example is Richard Neville, Earl of Warwick, from his wife's heritage. Although this is seen in other countries, when a woman is the last heir of her line, it can be used for a male when such a male is initially a co-lord with his father or other family member, and upon the death of such family member, became the sole ruler or holder of the title in his own right, alone. That is wrong. That is deliberately wrong, because suo jure means by oath, or his or her oath, and when he or she puts an oath to something, that's swearing it to be theirs, or swearing to uphold a duty or something like that. It is on that oath that they draw the power. So when a king, for instance, is coronated, or when they're crowned as a hereditary an heir, right, title to being an heir, they take an oath to fulfill that position or whatnot, right? They swear to it. That's where it comes from. Anyway, it is commonly accounted in the context of titles of nobility or honorary titles, e.g. Lady Mayoress, and especially in cases where a woman holds a title, her own bloodline or accomplishes rather than through her marriage. And that's not true either. It's most commonly encountered in contracts when somebody swears or affirms signing their name to a contract promising to fulfill it. Declaration of Independence, of course, is a primary example of that, but we all sign contracts without realizing that we are, in fact, putting into force through our oath that the promise to uphold that contract. And some of those contracts are really bad. But we just sign them anyway without thinking so much about it because we have to, and in most cases it's because we're ruled by this fraudulent banking court. Anyway, an empress or queen who reigns, suo jure, is referred to as an empress reignant or queen reignant. Those terms often being contrasted with empress consort or queen consort. Empress and queen are, however, often used alone to refer to either a regnant or consort, the distinction being indicated by context. Now, in the U.S. Constitution, Article 6, all debts, contracts, and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. This Constitution and laws of the United States shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So some of that is added in old revisions, such as the judges in every state shall be bound thereby. That is not necessarily contradictory, but it is a restatement of something that was put into another part, and judges in no way are included in the Constitution because they are in fact contrary to other parts of the Constitution, as we will look at in a minute. Anyway, the senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation. There you go. So that second paragraph stating that judges in every state shall be bound thereby is a reiteration of all executive and judicial officers shall be bound by oath or affirmation. They wouldn't restate something like that. So that's incredibly unnecessary. But we'll also find out later in this video exactly why they included that about judges. Anyway, to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust in the United States. Under the United States of American Constitution, the American Constitution of the United States does not require religious test, but the banking government of the United States does when they force you to swear, "So help me God." The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crime shall have been committed, but when not committed with any state, the trial shall be at such place or places as the Congress may by law have directed. That's the reason why they include that reiteration with the judges, is because the judges clearly were not a form of decision-making in the Constitution itself. It was the jury. And considering the issues that the colonials had before they signed the Declaration of Independence and did all of their fighting, the issues they had specifically with crown judges that we have today, or otherwise banking judges, would mean that they would not include something like that in their document so that those people could then be wielded against them, against their will, and against the law that they were establishing. So that's a clear revision, of which there are, in fact, many. But even though there are clear revisions, it is important to note that the Constitution does not lose its force because of all of the revisions and fraud that's been done upon it, because there's multiple sections in the Constitution that keep it in force in spite of that, because of all the things that talk about, like that the section we read about things being to the contrary notwithstanding, and of course that nothing shall be construed to deny or disparage, and we'll look at that amendment in a minute. In the Sixth Amendment, in all criminal prosecutions, notice that term there, all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in favor, and to have the assistance of counsel for his defense. All of that is construed by a banking, a private corporate entity, which is what we call state and district now, but that's not the state and district they're talking about here, if that is indeed the original writing. Well, they pretend to follow this process because they write a process that's similar to it and follows along with it with very important distinctions. They summon you to jury duty, but they try crimes, and the decisions of judges that try those crimes are bound by final decree, and they always have to do with some sort of monetary involvement. What this is talking about is a group of individuals, citizens, who hold a free and fair trial, and the public trial does not require it to be quote-unquote open to the public. Public trial simply means that it is done openly. So you can, in fact, do it in a place where you're not where you're free from harassment or breaking up the trial or attack or any of these other things that they would do to try to derail it. You can do the trial without having the trial done publicly. It just simply has to be, it has to be done publicly, but it doesn't have to be, insecure is pretty much it. It can be secure, and it's done quickly, and it's done where the individuals, they only have assistance, not representation. They have to represent themselves. They only have assistance of counsel, which means that they are counseled, not represented. And they have, confront the witnesses, which would, of course, be what they would call the right to be against, to face your accuser, right? But in no place at all does this require you to be a quote-unquote damaged party. That has to do with liability in the banking court. However, in a constitutional court, you can bring charges against somebody without being a prosecutor. You can bring charges against somebody without being personally involved in it. You simply can witness a crime, and you go and let them know, and you become a witness against someone else. Now, in the Seventh Amendment, this clearly has been changed, where it states, in suits at common law where the value in controversy shall exceed $20, the right of trial by a jury shall be preserved. That would make no sense. that would probably more likely read shall not exceed $20. Right? Why would they have juries convened for amounts under $20? That's clearly revised and edited in there so that the banking courts can make money according to the Constitution, which they revise and edit and control fraudulently, just like if somebody stole somebody's king and then forced them to write unlawful edicts and things like that. That's essentially the concept here, except in this case they control the all the mechanisms that we have to read the Constitution, and we can't be sure of any of the Constitution, but that does not necessarily mean that it cannot be enforced still, and that these things are not available to us because we can follow the example that they did in the past with the Declaration of Independence, and we can do all the same things that they did because they showed us the way. And they also had to contend against a hostile uniformed military with very extensive and capable arms, which I don't think we have to deal with something like that today. Not like they did. Anyway, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. That is an addition than according to the rules of common law. That would void the statement of no fact being tried by a jury, because common law is an English creation, and American common law refers to the colonial period, the English common law that was enforced then. It does not have to do with American constitutional law, because common law is not the supreme law of the land, constitutional law is. So, in order to undermine the finality of a judgment by a jury, they would have to add that part then according to the rules of common law, where it conflicts with the whole sentence of something being tried by a jury and not being re-examined. They wouldn't put an other than. That's just completely bogus. But either way, this is telling you that it's not the judge. There is, in fact, in no place in the Constitution where it states that a judge's decision is final, only a jury's, and this is the only location that it states that. So yes, of course, they had to revise this. They also added the additions of judges and other crap like that because the people that wrote the Constitution did not include them, and it would be a dead giveaway that the banking courts that we have are fraudulent. Next, the enforcement component of this constitutional court is very important, but like I said before, between the enforcement mechanism and the establishing of the legitimate court, it is very important to have protection, and also to be on the lookout for methods of assassination, poisonings. Like, you can't go out to parties, you can't go do any of that stuff. You have to be completely insulated from the attacks that will come from these illegitimate banking thugs, because they will try and kill anybody who signs a deed forming a real legitimate court. If they don't, then most of these people will probably be executed considering the extent of their crimes, and the only way they can be held accountable legitimately is through the formation of a constitutional court done in deed, and when you pen your name to that paper, you put a target on your back. Anyway, it states, to provide for calling forth the militia to execute the laws of the nation, suppress insurrections, and repel invasions. That is your constitutional law enforcement mechanism. You will find no assistance from sheriffs, police, firefighters, any of those people. In fact, if they found out that you signed a document like that, most of them would be bound by their oaths and duty to the banking courts to kill you, and also to save themselves from the trials that they would be put up for in a real court. And so you need to have this component called back up, essentially, so you could have this court, once they do all this stuff, go around to the local community and swear militias to make them executive officers, right? Because the court would be the judicial officers, the militia, members of the militia being the armed, well, we'll look at that in a minute, they would be the executive officers. They would all have to be bound by oath. So the courts could swear them in and have them sign and put into deed their oath. And then those people would be bound and also appropriately, legitimately capable of as it says here, executing the laws of the Union. Under the Second Amendment, we get the constitutional definition of the militia, not any of all of these other phony, fraudulent ones, or the foreign militias that have historically existed. It states, a well-regulated militia being necessary to the security of a free state, which we don't have one right now, the right of the people to keep and bear arms shall not be infringed. That is your militia. They are all armed people. All armed people. That includes foreigners, mind you. This does not stipulate all armed citizens of the Constitution. It doesn't stipulate all armed citizens of the United States. It says the right of the people. That means all people. Nobody can be voided of their right, except, again, according to the Constitution, without due process. With due process, you can void them of that right, but without due process, of which it has to be constitutional due process, not banking due process. Otherwise, you, foreign or otherwise, are freely capable of carrying arms because you might actually be called up by a legitimate court to use them to compel criminals to trial. Now, we get some further clarification, but unfortunately this is in French, so you have to bear with me on my translations. This is the significant memory, of which that would probably be better translated to perhaps a testimony, right? We might use the word testimony, testament. To the jurors in charge and community of master embroiderers and chasubliers, I don't remember what that is, of the city of Fauxbourg of Paris against Denis Portier, Louis Pinot Veuve Deporte, Marie Magdalene Lebré Veuve Dimanche, Nicole Chatelou Femme Boussou, tous ouvriers et ouvriers. Okay, those are your overseers and overseers of quality, probably nobles, workers in the arts of embroidery and gold and silver in Fauxbourg Saint-Antoine. That's the Saint-Antoine. That's the city, right? Apollon de. So that's the named. Yeah, that's. And also against the religious women of the Abbey of Saint-Antoine intervening, and Jean-Baptiste Saint-Maitre. So this part right here takes a similar form as the banking courts of today do, where this is essentially a court document, which is being brought up in early French period, 17th century, when there was a crown. A legitimate, partially the legitimacy of the crown or otherwise is in question. However, this is what a prosecution would do, right? This guy's basically a prosecutor on behalf of the crown who is submitting a court document to the jurors in charge and committee of master embroiderers, right? So this is, in fact, a old example from 1735, actually, not 1600s, but 1735, which we can actually follow because under the constitutional document, example, constitutional law, anybody can be a witness, which essentially means anybody can be a prosecutor. The prosecutors can only prosecute crimes are the only ones that could prosecute crimes in fraudulent banking courts, as far as their regulations go, because their regulations are corporate. However, in the Constitutional Court, anybody can do a document like this. Anyone at all. They can bring charges as a witness to that Constitutional Court, but again, we have these banking courts, which are all based off of foreign interests, and they are designed like this, where the only people that can bring a charge are administrators, representatives of the crown, or in our case, administrators or representatives of our fraudulent government that we call the state government or the federal government. Now, in this document, it gives us a definition of not only what is a privilege, but what is a sovereign. It says the good of the state and interest of the public would employ the masters of gold and silver, particularly embroidery, to not something like abuse their privileges, right? Something like that. And the sovereign makes the exception of privilege to Fauxbourg Saint-Antoine and other of their privileges for the specific declarations, the professions of the masters and employees, or our employees. These masters are employees. The pretension of the named, or appellants, where we get our word appellant, of course, cannot be écoute. I don't remember what that is. So it's can't be directly contrary against the king, right, or the good of the state and the public that are in the is in the motive. So the privilege is awarded by the sovereign, in this case the king. So if the privileges are awarded by the Constitution, that makes the Constitution the sovereign. When you witness a crime and you bring it before a constitutional court, you're not doing so because you are personally afflicted or because you personally have a stake or anything like that. You are executing the law because somebody violated the sovereign, being the Constitution, versus somebody violating the laws of the sovereign, being the king. So they're two different concepts. And of course, the Constitution is a contract that we are all have a say in, the legitimate U.S. Constitution, whereas the fraudulent banking Constitution is leveraged upon us and we have no say in it. And those are the main differences. We have no say in how the court structure works in the banks, the banking courts that we have of the state bank corporation that we call government, whereas in a constitutional court, we absolutely do. That's the difference. We have a say, we can argue, we can give witness testimony, and we can't be silenced. Even if you're the accused, you have rights and privileges afforded by that document, thus making the document the Constitution, or the sovereign. And so in this context, them taking and revising and abusing that document is the exact same idea as somebody who steals your king and tortures him, or queen, and requires them to sign fraudulent paperwork. The people that do things like that historically have had the worst punishments possible or even imaginable done to them for those types of activities, because that action makes the entire nation look weak and also open to all sorts of dangers that can be leveraged upon them for their crown representative being taken. And in this case, they took our document and edited it to no end. Again, in their book, Law of Contracts, by John William Smith, Esquire, from 1885, we get a description of exactly what the banking court is. And the reason why you can see the stark contrast between the constitutional courts that we don't have anymore. Those were removed from force or practice during the Civil War. And all we have now are these banking courts, which have usurped the lawful, legitimate sovereign, the U.S. Constitution. Here it states, at an earlier period of our law, statutes merchant and statutes staple, which are both contracts of record for the payment of debts, were commonly in use. Subsequently, recognizances, yeah, that's plural, in the nature of a statute staple were established. D. Here's where you get your statutes of laws of statute and stuff like that. These contracts are, however, now almost unheard of. The only contract of record with which we now occasionally meet is a recognizance, and that oftener in matters in which the crown is concerned than between subject and subject. Thus, an ordinary mode of compelling a witness to attend and prosecute or give evidence in a criminal case is by recognizance, in which he binds himself to the Queen in a certain sum conditioned for the performance of the duty imposed on him. That's called bail. And in any case of his making default, that sum accordingly becomes forfeited and payable to Her Majesty. The commonest case of recognizance between subject and subject was that of bail, right? Which has, however, become less frequent since the act restraining the right to arrest on mesne process. It may be added that statutes and recognizances no longer affect lands unless registered under statute 2 and 3 vic blah blah blah, and the land themselves have been actually delivered in execution. And there you get your description of the banking court, which can only act in crimes that relate to monetary value, whereas a legitimate court acts on things that aren't necessarily but can act in things of monetary value. Our legitimate constitutional courts, anyway, that we don't have. In this sense, this person is describing recognizance as what we have today, which is where if somebody is injured, that injured party does not get a payout from the surety that is given. The surety that's given goes back to the people or to the quote-unquote state entity that we're subject to, fraudulently, of course. So if that entity that's causing the damage is in fact the entity itself, well, they'll just pay themselves, right? It's a revolving door, and that's recognizance. That is what we are currently under right now. That's the banking court, and in the banking court you will never win, ever. Now I should note again that in order to set up these legitimate courts, the individuals doing so have to be fully prepared, like those that signed the Declaration of Independence, to pledge their lives and their fortunes. They will do everything possible. Yes, they'll try and kill you. If they can't do that, they will try and kill people around you, people who you're related to, anybody that they can possibly threaten, coerce, or do damage to. They will also try and take everything that you have. They will pull your licenses, which are all fraudulent anyway, mostly anyway. They will use any means under that they could possibly fathom or imagine, any means necessary to try and stop the presence of a legitimate court, because they're dominoes. Once a legitimate court's set up and once there's a public trial, everyone's going to start doing it, because everyone nowadays, there's very few people that are not on one side or the other. They're either mad about being abused or they're the abusers. So things have gotten a lot more clearer nowadays. And so now's the time to re-establish constitutional courts, and the people doing so will definitely be heroes. Thank you. If you have enjoyed this video, please share it, subscribe to my channel, join my newly formed Discord. If you so desire, you may support my work at PayPal, Cash App, any of the options available. Also, there are free books available at the links. And if you order directly from me, sending a message or whatnot, I'll include my email here. Then I can send you physical copies of the books at a discount.